All right.
Okay.
You guys,
Yes.
you saw
Yeah.
that, right?
Yeah.
Okay.
I'll take a motion to it one. Okay, if we got the audio.
Yep, you're good.
I'll take a look. Is it on?
Welcome, folks, to the follow-up hearing at the from the Harbor Inn. The parties are not all here right now, so what we'll do is take a recess of the hearing until the parties are all here, and then we'll be back with you. I think that the the visual will stay on, but the audio will be closed. Do I have a motion to go into recess
So moved.
Second.
until the parties come back? Second. Any discussion? All those in favor say aye.
Aye.
And that's unanimous. What we'll do is we're gonna, Tracy, you can open up. Okay, welcome back, folks. We've been in recess for about 12 minutes on the hearing schedule for this evening, and we're now going to commence with the remainder of the hearing matters. Now, the way we left it off last time, you gentlemen, the councils for both parties, were going to chat and maybe see if something could be worked out or whatever. So do you have anything to report in that nature?
Yes, I do, Mr. Chairman, and members of the board, and members of the public. John Lawler, Gerald Oderheide, Chris Senior, the town manager, and I have been discussing this, and we just came from a meeting which was, I think, a very productive meeting, and I believe it shows a great deal of spirit of cooperation amongst everybody. And we do have certain items that are tentatively in agreement. There's one issue that we're still trying to work out the details on, but I think it's something that can be worked out, that will address the concerns. The concerns of the town have been that there is a complaint and evidence of noise that was causing a disturbance. The licensee, from their perspective, they're trying to control the activities there so that they're all in compliance with the law. Obviously, something happened on those other evenings, but we're now at a very good stage of working together, and I really must say that we had a very, very productive, strong evidence of cooperation, and I believe that the town displayed to the licensee that the town wants to cooperate with them to ensure that their business is successful, because if their business is successful, the town overall business climate is successful, and everyone stands to benefit from that. I believe I just want to highlight what some of the issues were that that I think we are in agreement on. One of the issues was that inability or difficulty in residents and other people reaching the appropriate management to call to their attention that, hey, there's a problem, the music is too loud, for example, because sometimes the management may not be aware of it, although we would think that they should be, but they may be busy doing something else and they don't hear it the same way that someone off the property would hear it. So the licensee has indicated that they are sensitive to the neighbors' concerns, and that they want to work together with the neighbors, and there will be some things being done in the future between the licensee and the neighbors to sort of improve upon and enhance the working relationship. In the meantime, one of the things that I believe that we've come to an agreement on, and Mr. Lawler can certainly clarify that or correct me, right now the license says that cell phone numbers of managers will be given upon request. That is going to be changed to names and cell phone numbers of all managers shall be set forth on a list of managers. The exact language may be massaged and changed, but shall be set forth on a list of managers. The list will be distributed to the town, to the police department, and area residents, and shall be posted at the front desk, function office, and function room of the inn. Any changes in the personnel or cell numbers must be distributed to those foregoing parties. Employees shall attempt to respond to all calls concerning issues promptly and with courtesy. And when appropriate, the managers shall work with the area residents, the town, and the police department to address noise and other issues. I think everyone could recognize, certainly it was stated by several of the witnesses, that they didn't feel they had anyone that they could call or contact. Had they perhaps been able to do that, then there wouldn't have been the problem that led to the hearing. We all think that this is one thing that will help improve the relationship and hopefully eliminate similar problems in the future. Certainly, if there's some exceptional circumstance, I'm sure the neighbors or anyone else, including the establishment, will call the police if there is a problem. It's in their interest to be sure that public safety is followed for everybody. In particular to the venue at the Breezer, the existing license said that the doors, including the accordion doors leading to the patio, must be closed by 8 p.m. except for ingress and egress. We are going to expand and clarify that the windows shall be, and the doors shall be closed leading to the patio by 8 p.m. except for ingress and egress. One of the issues that I'll comment on more in a moment is how do we deal with the amplified music and keeping that amplified music contained. Because not all amplified music is necessarily loud amplified music. You know, if you ever go to the MBTA in Boston, you go to a Park Street subway station, quite often there's people inside the station playing a guitar or some other instrument that's on an amplifier. That technically is amplified music, but that's not the type of situation that we're talking about here. There's also going to be a requirement that a suitable staff person shall be tasked with the responsibility to ensure that the doors are kept closed by 8 p.m. Or earlier if, and again here's the issue, amplified music that is disturbing is being played. If the idea is to keep contained in the function room music, whether it's amplified or not, that is creating the disturbance that led to the hearings. As relates to the inn, again, a suitable staff person will be tasked with the responsibility in the inn to ensure that the windows and doors are kept closed by 8 p.m. Or earlier if there is amplified music that is going beyond the function room and the patio or is otherwise creating a disturbance. The issue that we're still trying to work out, the devil's in the details, as they say, and the issue that we're trying to work out is to develop an appropriate standard so that the licensee clearly understands what the limitations are, so that the town is satisfied with those limitations, so that the public knows what those limitations are, and so that the police know what those limitations are in terms of the music. Because there's certain amplified music that may occur, as Mr. Lawler correctly pointed out during the meetings that we had. A reception that starts at 5 o'clock, from 5 to 6, may likely have some type of music, background music. It's not intended to be so loud that it drowns out conversation. If anything, it's supposed to be music that encourages conversation. Similarly, during a meal at a nice function, you would have what is commonly called dinner music. Again, that music is not the type of loud music that existed here and that caused the problem. The devil in the details is how do we differentiate between conversation music and dinner music versus loud music that is causing the problem. Louder music that typically encourages people to get up and dance, and things of that nature. And so that's what we're trying to work on, to come up with a fair and reasonable solution. Mr. Oderheide said without any prompting that if people can't, if the music is so loud that people can't sit on their decks and talk, that's not right, and he wants to address that. So we're trying to come up with some type of a standard. There's different ways of doing it. We weren't able to accomplish that this evening, but there is I think it's fair to say that there's a commitment between the town and the licensee to work on that, so that there is something that's fair, reasonable, and measurable in terms of whether something is in compliance or not. The benefit to the town, or the safety mechanism to the town, is whatever we ultimately agree on, if in fact it doesn't work out and it still is noise that is causing a disturbing to the neighbors or disturbing to the area, that still comes under the entertainment license, and we may have to address that again at a future hearing. We're hoping that we can arrive at something that will set a good, workable standard for everybody. So what I believe, and Mr. Lawler, I'm sure will want to make some comments, and perhaps Mr. Senior, the town manager, as well, is that we need the time to work out those devils in the detail, and so we think that a 2-month extension of the existing license, which under the same terms and conditions as it was extended back in December at the hearing, should be voted by the board to bring us towards the end of March. By that time, we hopefully will be able to arrive at the necessary guidelines that we need, if we're able to, and then the board can still say, okay, these are the guidelines, let's see how it works, come back in July, after there's been a period of time, to see how this is being carried out, and it can be readdressed then. But clearly there's a genuine desire on everyone's part to resolve it.
So, if we agree to whatever was settled on this matter, or once if we came to agreement on that, that would then be built into the renewal of the license when we actually renew it. So theoretically, at the point that's done, we would then renew the license for the rest of the year, or whatever it is we decide, but these would be the new conditions added to the license, right?
Correct, because
Okay.
the license currently has certain conditions. These are basically the refinement of those conditions.
Yeah. So then my other just question is, 2 months seems like, to me anyways, like a bit of a long time. Can't this be negotiated less than 2 months?
I would think that it could, and if for some reason that we can't, we would be explaining the reason. If the board was satisfied with the explanation, the board would continue it further. If not, but I think we could.
That's fine. I mean, one of the things we discussed, it wasn't definitely agreed upon, was the fact that we could bring a sound engineer in there, in order to, again, determine what low acceptable volume is. I think we get wrapped around the axle on the word amplified. So I think it's important to understand, first of all, a couple different things, and it was a very, very good meeting, by the way, and I think there is this genuine, spirit of cooperation. I think you recognize that my client brings a lot to Cohasset, and it's a great place to have a wedding, obviously, at the different venues that he owns. With that said, a couple things. One of the people, and I learned a lot in this particular case, even though my son was married this fall, they always have a wedding coordinator. So the wedding coordinator is there for all 5 hours of the wedding. So the wedding runs from 5 to 10 or 6 to 11. The wedding coordinator is always there on the floor, right with the bride, running everything. And we're gonna make sure that that's the #1 person on the list, okay? Because I think it makes, she was gonna testify, as a matter of fact, Casey Bugsoni was gonna testify if the hearing continued about what happened on the 25th, but she clearly has an interest in making everybody happy. It doesn't make people happy when the police officers roll in and the bride and the groom see that and it's disturbing the wedding. So she, in this particular case, has a genuine interest in resolving all the problems before they become greater problems. So that would be the first number on the list. The other thing, though, we're kind of, figuring out, remember, this is a beautiful venue, you're on Cohasset Harbor, beautiful summer night, fall night, or whatever, and that's what people want, right? So there's a typical chronology to a wedding. If it starts at 6 o'clock, for instance, and I guess a lot of the weddings start at 6 o'clock. The one that, in this particular case, on September 25th, started at 5 o'clock, but there's a typical chronology. The first hour is the cocktail hour, and that's out on the patio. And the music is not out on the patio. Whether it's a DJ or a band, the music is in the function hall, but the doors are open and the music does come out to the patio. But it's music that elicits and enhances, as Attorney Lemke said, conversation. So I don't think that's gonna be problematic. All right, 6 to 7, cocktail party ends. 7 o'clock, everybody goes back in the function hall, introduce the bride and the groom, the wedding party, initial dance, they sit down for dinner. That goes for a good hour. That's, again, it's conversation type music, it's within the function hall. The patio doors, though, is still open pursuant to the current license and all that. It's only then, when the dancing begins and the music gets ramped up, that I think it becomes problematic. So that's a situation where we want to be able to address it, and that's, a situation, does it fall before 8 o'clock? I mean, the current license is 8 o'clock, although it does say the music stays within the confines of the property of the Cohasset Harbor Inn. And that's what we'd try to do. And so I think we had a problem with amplified music being eliminated. That would be very, very problematic. It would be disastrous, and we'd lose a lot of business. And in fact, one of the pieces of evidence that was gonna come out tonight is that even based on this hearing alone, there are people out there who are withholding their deposits right now and putting their decision in abeyance right now whether or not they're gonna have a wedding. And that would have come out in the testimony. And clearly, that's something that we don't want to happen, and I don't think the town of Cohasset wants to happen.
Okay,
Thank you.
yep. Steve, did you turn this?
Yeah, I direct my questions to Attorney Lamke to start with. One of the things that I would suggest that be added to the order of conditions that go along with this is that the names and contact numbers be listed and updated as soon as practicable. One of the items that we've recognized with the operator and the various business that they've had is that we do not often have a current listing of management or their contacts. The second piece of this, and I do want to make sure that this part's recognized. By the way, thank you to both parties for having what sounds to be a productive conversation. Ultimately, the reason for the entertainment license being specifically structured as it was, and I recognize, Attorney, that you weren't here at that point, but it actually took a good portion of one particular hearing to address this issue, and specifically with respect to the inn. And that led to the two items listed on page 2 of the entertainment license. The first one, which addresses windows being open and closed, etc. And the second, entertainment permitted inside until 1 a.m. Monday to Sunday, as long as it is not audible beyond the lot line except caused by temporary opening and closing of doors for ingress and egress. And I think that part is clear. It's clear as a bell. It's not that the town is asking to restrict amplified music within the confines of the building. Absolutely not. We would like very much for that to be a successful venue. And as a matter of fact, it had been a venue used for that purpose by the prior owner under similar conditions. So those conditions, as originally scripted, still seem to apply, and the verbiage is crystal clear. I'm not certain, from my perspective, that they need a great deal of negotiation. And the final line on that page 2 is adopted by the Board of Selectmen May 9, 2016, and agreed to by the licensee. So none of this was a surprise. And as a matter of fact, the council at the time for the licensee was actively a participant in formulating this license with the members of the LLC. So I just use that as a reminder.
Okay. Anything else?
Thank you.
Alex, have anything? Paul, and then Diane?
No.
No, Paul?
So I guess the question I have is for the wedding coordinator. Is that going to be an employee, or could it be a family member? And if that's the case, there should be a default employee, or,
No, it's an employee, it's
Always.
someone who's involved in setting up the wedding and running the
because
wedding
I
and all that.
would
So
not
it's-
want to have someone who is organizing the wedding that is not part of the
No,
corporation is responsible. So that if that's the case, there should be a designated responsible person with a cell phone
Right.
available.
yeah. By
You'll be
definition, and I
contacted.
just learned this as well, wedding captain, wedding coordinator, whatever, it's an employee of the entity, this,
Okay.
in this case, Cohasset
As
Operating.
long as that's clear.
Anything else? Chris, do you have anything to add here?
No, I appreciate Attorney Lawler's efforts today to get this meeting together. And I think that there was a genuine spirit of, let's see what we can work out. And, by the way, include the neighbors. There was really a stress that the town, we don't wanna have to be involved in this. If we get involved, it means something's not working. So, developing that relationship, and again, I think there was a genuine conversation about developing that relationship. And it takes some time. So we'd like to help in any way we can to help develop that conversation so that things can be solved before they have to get up the ladder in any way.
Okay, I do notice some of the neighbors are here. If any of the neighbors or whatever, make a brief comment on how they feel this may be flowing, or you don't have to, just,
I'd be happy to. Can I sit up here, or do you want me to do it from here? What's-
excuse me.
Yeah, just a point of order, I just wanna make sure, cause we're in an open hearing that we asked not to have public comment for. So I think until we mechanically either close the hearing and go into a deliberative phase,
Okay.
or we do something mechanically with the structure of the meeting that we not entertain public comment.
Well, I appreciate that distinction. We're optimistic that we're gonna arrive at some comment, and a neighbor's comment may have some benefit to the points that we're trying. So I would ask if the licensee has any objection to the neighbors commenting on what they've heard so far.
No, I would just ask, and judges do it all the time, you can consider what's being heard, but don't consider it to be evidence in regard to some ultimate decision. I think you all
Yeah.
as fact finders can do that, and I'm fine with that.
Definitely not. My view, and I'm talking to the board, is that they're in the process of coming to a resolution. I'm just trying to get, like Steve came up with a couple of good ideas, and you did too, just any ideas, and that's all I thought would be beneficial. So, is that okay with any objection? to
That's
that?
fine, I'm not opposed, I just wanna
And
make
to-
sure we were doing everything properly.
So-
Agree that we won't take anything.
Oh, no, not,
except
this is,
that you're-
this is merely to maybe throw out any suggestions that might help, rather than wait for there to be a resolution and then have to redo it. So with that said, then unless anybody, the board objects, briefly, just to add any thoughts or any ideas that might help with the resolution, you can come forward and address your name.
Thank you. Can I sit here too?
Yes.
All right, my name's Hugh Kelly, 15 Border Street. Question I've got, I really have a few questions and a few comments, and I'll try to be very brief. I think when it comes to negotiations, one really great term I heard not too long ago was constructive ambiguity. And what it is, we can come up with solutions, and everybody has their own interpretations of it. And I think what I'd like to get to, as soon as we can, is some clarity. I think a lot of things seem to be opaque. I think, first off, I think it's great we're having a conversation. I think it's really good we're gonna get some names of people to call. I think the word I heard was, at some point, if there is an issue, the people on the harbor would call this person, and they would get back to them promptly. And I think promptly, as I look at my experiences with the prior gentleman who was running it, Anil Papat promptly became the next day. So I guess we need to put some parameters around just what's the expectation once the neighbor calls, trying to get some action because there's an issue. Or otherwise, is it 5 minutes, is it 20 minutes, is it an hour? I don't know. We wanna be constructive, but we need to have something along that line. I think as we talk, and as much as we wanna parse it and try to try to make it work. I think there's been such significant changes on the harbor with a very different physical opening of 68 feet that wasn't there before with the prior owners up until 2012, 2013. And then you've got an extremely different business model that basically is a wedding venue. So you've got a very different dynamic. They've collapsed, they've come together, and we have more noise. The key point, it's one key point, and that is amplified music. And I think as it relates to the business, I think all of us on the harbor want this business to be successful. We hope they pay taxes, we hope they do a great job, and that they're here for 20 years. I think probably one of the best ways of getting that accomplished is they figure out the amplified noise issue. Because if you look at the general guidelines that this board put together, every time there's amplified music, they're in violation of it. And we're not calling every time. But I think this is the type of situation where if you look at it, they are in violation. So I think what we need to do, and tonight's not the night, I know it takes some negotiations, but we've got to figure out that they can have amplified music. There's just got to be doors that are shut during that period of time. And I think the council basically tried to talk about a chronological, perfect wedding in terms of how it typically unfolds, but unfortunately, there's no typical wedding. You've got different people coming in from different areas of different towns that have different noise level interpretations. So I think we have to get more specific, or we're gonna be back here again, because there'll be an awful lot of noise and disruption. But I hope it works. I hope the business is successful. We'd be very happy if it is. But I think for us to get there, there needs to be more clarity, and I look forward to everybody here getting more clarification and codification of these real guidelines, and really focus in on the amplified music that basically was not there before.
Okay.
Okay, thank you.
Thank you, sir. Any other we're looking just for ideas for the negotiators to consider. You wanna come up and identify yourself?
Good evening. I'm not a neighbor. I work for Jerry Alderheide, and my name is Nadia and Lucy. And I was sponsored from France. I'm sorry about my English. To come in the United States and open the red line for Jerry Alderheide. And I heard and I was trying to understand everything. I can promise you that the doors, they're always closed, because when it's a summertime, it's very hot, and when you have 250 people inside, you want to keep the doors closed because it's so hot, and you need to keep the AC on. In the wintertime, it's the same thing. There is always a waiting a helper there with the bride, because even if she's not there, it's not possible in a way. And I'm sure you're all married, and I'm sure you all had a good time for 5 hours, a good dinner, happy family, you dance, and it's unbelievable because he was open for 17 years, and it's only started the noise situation. And Gert Alderheide had just purchased Cohasset Harbor and Atlantica, and all of a sudden all the problems started. But I don't believe before you had this complaint. So that's what I think and what I feel. And he's been bringing a lot of business in Cohasset. He cleaned Cohasset basically, because I remember when I came here.
We're here
Before
for,
he
I don't
brought-
mean to interrupt you, but only if you have an idea for the negotiators. This isn't,
Okay.
yeah, okay,
I'm just-
so.
The ideas is, it's been going well for many, many years, and now it's not. I
Okay.
don't understand.
Yeah, thank you very much.
You're welcome.
you.
Thank you, and have a good evening.
You too.
Anybody else with any ideas? Okay, we'll cease on that portion. And now we're at a point here now to the board there that we're being asked to. One other final thing, is there any thought on and just for you folks to talk about, noise absorbers and so forth. I don't know whether the technology or anything like that's possible, just something for you to explore, I think. I mean, I know in some businesses and stuff, they can put noise absorbers out where those bushes are in front, and that may itself help a lot. I don't know whether sometimes too in these situations, you can do landscaping that absorbs the noise, so that there's physical stuff that you might get an expert of some kind to help you with, and that may just suck up noise, you know, and help with that bouncing off the water. It's kind of a
I think
technological.
that's a good idea.
Yeah, it's a technological thing. With that said, essentially what we're being asked for is a 2-month extension under these conditions. My view is that if we did do that, it would be an extension of this hearing, and we would be in the posture as we are tonight of 2 months from now coming in ready to finish the hearing if you haven't settled, you know.
That's fine.
We would expect that 2 months would be enough, but it's up to the board to make any motion relative to this one that they wanna do, excuse me.
I'm sure that hopefully we'll arrive at some resolution before the 2 months, and we'll certainly be reporting back to the board as soon as we think it's ready to be reported back to the board, hopefully well in advance of the 2 months.
Yeah, if that was the case, we could then, but if we have to call this hearing for a date certain, how do we work with that? Which makes me
Well, it's a board scheduled hearing, so the board can schedule the hearing for a date in 2 months, but also subject to the caveat that if the parties are prepared to report back to the board sooner than the 2 months, all the board has to do is list it on an agenda, and I'm sure given the attention that people in the community had to this, that the normal means of communicating the board's agenda would alert people. It's not like an advertised hearing where you have to give a specific date and you can't change it.
So we could set a hearing, and if something came up, we could probably even incorporate that in one of our regular meetings, if there was a settlement for us to review, because that won't take as long as a full hearing. I'm just thinking out loud. Jack?
I think it'd be more appropriate to have 30 days, and if they can't get it done in 30 days, they come back to us and tell us why. I mean, I can't see why we can't get this done in a 30-day timeframe. I think stringing it out 2 months is, it's gonna take 2 months if we give them 2 months. I'd
One
like
thing-
to see this wrapped up.
Yeah, the only thing that did concern me is we wanna get this done closer to the spring and summertime for everybody's benefit, so could you guys live with something sooner than?
As Selectman
30
says, if necessary, we can come back with some problem, but I would hope that we would be able to.
Yeah,
I mean, this is not, a uncommon problem in
No.
licensed establishments,
Right.
throughout the state and the country.
okay. If that's the case, we should figure out what that date would be
Yeah,
before
so-
people make a motion on it.
Our regular meetings in February are the 14th, which is Valentine's Day, so I don't know if we wanna do that for everybody, because some people might have lives. And then we meet again on the 28th.
Well, we wouldn't.
My 3 girlfriends.
We're gonna schedule a hearing, so it would have to be not a meeting.
Oh, I
because we may
misunderstood,
end
I
up-
thought you said we could probably do it on the same night.
Only if they would say we have a settlement,
back.
then we could put that on the agenda. I suspect we'd have that done in a half hour, right? But we'd have to schedule a hearing if that doesn't, So if we did a hearing, this is what, January 11th, so, the 23rd of February, I'll throw it out. That's more than 30 days, but Thursday, the 23rd. And that, there's 2 dates between that, so if they've come up with a resolution, which.
Well, excuse me, I may not be able to do that Thursday. And also, I should point out that week is, I'm told, is school vacation week, if it makes a difference for anybody
Yeah,
in
that
terms
might
of
be fine.
schedule.
Okay, so we could do the 16th of February, that's a week earlier.
Thursday nights, that far in advance may be problematic for me.
How about the 15th?
15th, that's good.
Just for clarification, do we have to schedule it on a night outside of a regular Board of Selectmen meeting?
Well, I was thinking that we would, because if we have to have a hearing, we're gonna be here for quite some time, it'll
Okay.
absorb the whole evening, right?
But I mean, it's just a continuation, so I don't know.
No, in other words, they may come we have to have a date, I'm hoping subject to, but we have to have a date in which we're gonna say there's a hearing, because the parties need to understand that. We need to bring this to a conclusion.
Why don't we add it as an agenda item on the 14th and,
That's what I think.
Either that, or just very simply bump it for the extra 2 weeks,
yeah,
set the expectation with the parties that we expect to hear about progress earlier than the deadline being the 28th, right? Otherwise, we're good to go for a continued hearing on the 28th.
okay.
All right?
Which a part of our regular meeting.
As a part of the regular
But
meeting.
if we do that as part of the regular meeting and we do a hearing, we're not gonna, we're gonna, we're talking 2 or 3 o'clock in the morning, because a meeting would take us till 9:30.
But this is a hearing, and we might be out of here in 15 minutes.
Yeah,
I would say that, based on conversations that we've had and possible shortening of the scope of the issues in the hearing, that if you schedule this for later in your agenda as a last item, that it's certainly not gonna be as long as it was the first hearing. And that it would probably be, I would say, a couple of hours, I would imagine, tops, unless.
However, it looks like it would be likely that we're not gonna even have that though, too, is what I'm thinking, is what we're, right?
I'm optimistic
But yeah,
that
we're up to.
reasonable minds will come to some logical explanation.
Okay, so does the board wanna, that would make this on the 28th, as part of our regular meeting, and it would be at the end. And if we hear something sooner, we can entertain this sooner, at a sooner meeting. So what we need then is a motion, follow me, council, we need a motion to continue this hearing until February 28th. Is that correct?
February 28th, with the proviso that the parties are certainly encouraged to report back earlier to the board on any progress.
And with the understanding that the entertainment license is continued until that date as well.
So the motion would have to extend the hearing till the 28th, continue the license until the 28th, and the whole thing is, has a proviso that if you come to a resolution sooner, you can come to that, and we can legally vote on that even though, is that correct?
Yes.
All right, can anybody make that motion, or do you wanna discuss
Yes,
it?
but I was actually gonna propose that you just break the motion in two, all right? So move that we continue this hearing till February 28th, 2016, with the proviso that an earlier settlement could be brought before the board at that time.
and is encouraged.
And the board encourages that action.
Okay, let's vote on that, then you could do the second one to make, there's a motion, do I have a second? Any discussion?
I'd just like to amend it to include 9 PM or whatever time you think is reasonable, because
Oh, it has
we do
to-
have
yeah.
to have a time.
There has to be a time for a motion,
And we
right?
can do it earlier in the meeting too, I mean,
Yeah, let's do it in the
Right,
beginning.
you could say for
No, we
a
won't.
date, you may not know what your agenda is going to look like now for the 28th, so you could allow Mr. Senior to schedule it for an appropriate time on that evening.
We don't need to say a specific
No.
time?
okay, then I
Withdraw the motion.
withdraw my motion.
So we don't need to add that into the motion, right?
About the specific time,
We don't.
no.
Okay.
Okay, the motion's made, is it seconded?
Second?
You can't any further discussion? All those in favor say aye.
Aye.
Opposed, nay. It's unanimous, Tracy. Second part of the motion, Steve?
Okay, move that the existing entertainment license for the Cohasset Harbor Inn, Brisa, and Atlantica.
You already renewed Atlantic.
Oh, that's right. I'm sorry, for the Cohasset Harbor Inn and Brisa.
Didn't we renew Bruce?
No, the entertainment license for the Cohasset Harbor Inn with all the venues, there's,
Which
Brisa
one
is a venue, the
license?
Inn is a venue.
Go ahead.
One more time. Move that the entertainment license for Atlantica and the Cohasset Harbor, I'm sorry, for Brisa and the Cohasset Harbor Inn, which we have currently temporarily extended to January 31st, 2016, now be further extended to February 28th, 2016.
Is there a second?
Second.
Okay, any further discussion? Hearing none. All-
Excuse me, 16th of 2017.
Thank you very much. Which is, read the motion again? or simply update it to the correct
Reflect
date.
the current year, yeah. 2007, Tracy, have you got that?
2016 was a good year, Tracy, so.
Okay, so the motion's made. Second, any discussion? I hear no discussion. All those in favor say aye.
Aye.
Opposed, nay. That's unanimous, Tracy. Okay, that brings us, unless there's any objections or anything, to the conclusion of this hearing. Do I have a motion to end the hearing? Oh, yes, sorry,
Adjourn.
Adjourn the meeting.
There's no topics left, right?
sorry about that, yeah.
Probably
Um,
not reasonable.
yep.
Okay.
There are no topics unreasonable. I don't have any topics that were not reasonably anticipated by the chair, and therefore I will ask for a motion to
A
adjourn the
motion to
meeting.
adjourn the meeting.
Second.
Okay, any discussion? All those in favor say aye.
Aye.
Opposed, nay.
Okay.